What would it take to make a person disappear? Not through violence, not through any dramatic event that people would remember and talk about for years, just through paperwork, through a signature on a form, through the word of one man who decided, on a particular day in 1860, that his wife had become inconvenient. That is where this story begins, and the more closely you look at it, the more questions it leaves behind. In 1860, a woman named Elizabeth Packard disagreed with her husband about religion. That is the starting point. A disagreement about belief, about interpretation, about the kind of spiritual question that families have argued over for centuries, without any lasting consequence. But in this case, the consequence was not an argument that faded over time. It was not a period of silence between two people who eventually found a way to move forward. It led to something that, even knowing the legal context of the era, is difficult to fully absorb. Her husband had her committed to an asylum. There was no hearing. No independent doctor evaluated her condition. No evidence of mental illness was presented to any court or medical authority. No one outside the marriage was asked to weigh in on whether this woman was well or unwell, stable or unstable, a danger to herself or to anyone around her. None of that was required. Under the law of Illinois at that time, a husband's word alone was legally sufficient to have his wife removed from her home and placed inside a psychiatric institution. His testimony was the beginning and the end of the process. That was the law as written. That was the law as applied. And so Elizabeth Packard was committed to the Jacksonville Asylum in Illinois. She stayed there for 3 years. 3 years. That number deserves a moment of attention before moving past it. 3 years inside an institution. 3 years away from her home. 3 years separated from her 6 children, who remained outside those walls with a father who had just demonstrated, with full legal backing, exactly what he was willing to do when disagreed with. 3 years during which Elizabeth had no clear legal mechanism to challenge what had been done to her, no straightforward path to walk out, and no guarantee that walking out would ever be possible at all. At first, it seems like a tragic story from a distant era, with laws we have long since corrected. But this is where it becomes unclear, because when her case was eventually heard by a jury, something happened that is worth examining carefully. The jury deliberated for exactly 7 minutes. 7 minutes before reaching a unanimous verdict. Their conclusion was that Elizabeth Packard was completely sane. Not probably sane. Not difficult to evaluate. Completely sane. 7 minutes was all it took 12 people to agree on that. That raises a question that does not have a clean answer. If a jury needed only 7 minutes to determine that this woman was sane, why did the system that held her require 3 years? What was happening during those 3 years that a brief deliberation could resolve so quickly? The gap between 7 minutes and 3 years is not easy to explain away. It does not fully make sense when held up against the idea that the system was simply doing its best to evaluate a difficult case. Some would argue that the legal processes of the time were slow, overburdened, and imprecise. Courts had limited capacity. Asylum populations were growing. The machinery of the 19th century legal and medical system moved at a pace that would frustrate anyone who had an urgent need to challenge it. Under that explanation, the 3 years represent inefficiency, not intention. The system was not designed to trap Elizabeth Packard. It simply failed to release her as quickly as it should have. That explanation is available, but it becomes harder to hold on to when you look at what happened after she was finally released. Because the story does not end with a verdict. It continues. And what it continues into is something that raises entirely different questions. The night before Elizabeth Packard was released from the asylum, her husband acted. He rented their house to strangers. He sold the furniture. He emptied the bank accounts. He gathered her wardrobe, her personal notes, her belongings, and he took the children. Then he left the state. By the time Elizabeth returned to the place that had been her home, there was nothing waiting for her. Not a chair, not her savings, not her papers, not her children. The house she had lived in had other people inside it, and she had no legal standing to challenge any of what had occurred. This is where the legal context of the period becomes relevant in a way that goes beyond background detail. There existed at the time a legal doctrine called coverture. Under coverture, a married woman did not hold an independent legal identity. The moment she married, her legal existence merged with her husband's. She could not sign a contract. She could not file a lawsuit in her own name. She could not write a will without his consent. Any wages she earned belonged to him. Any property she inherited transferred to him. And the children of the marriage were, legally, his children, not hers. Her connection to them existed in practice and in feeling, but not in law. Hence, something goes wrong inside a system. The first instinct is usually to look for an explanation that does not require the system itself to be the problem. That instinct is not unreasonable. Most failures in history do come from ignorance, from limited knowledge, from people making decisions with the information they had available at the time. And the 19th century asylum system, according to the most widely accepted explanation, fits that pattern fairly well. The official account is not difficult to find. It appears in textbooks, in historical surveys, in legal histories of the period. It is the version most people encounter first, and it is worth understanding clearly before examining where it becomes harder to accept. The accepted explanation begins with the straightforward observation about medicine. The 19th century had a deeply limited understanding of mental illness. That is simply true. The tools available to physicians of that era were primitive by any modern standard. There were no standardized diagnostic criteria. There was no agreed-upon framework for distinguishing between different types of mental illness or for determining how severe any given condition was. The vocabulary used to describe psychological states was inconsistent, vague, and often rooted more in moral judgment than in clinical observation. Physicians were working in the early stages of a science that had barely begun to organize itself. That context matters. It does not explain everything, but it is real. Within that context, the commitment laws of the period reflected what physicians and lawmakers believed they knew. If a person's mental state could not be reliably measured by a doctor, then the next best source of information was the people closest to them. Family members, in the logic of the time, observed the person daily. They knew what was normal for them. They could identify changes in behavior that a doctor meeting someone for the first time could not detect. Husbands, in particular, were trusted because the legal and social structure of the era placed them as the head of the household and the primary authority on matters within it. Courts deferred to that authority because there was, according to this explanation, no better alternative available. Asylums themselves, in the original conception, were not intended as places of punishment. The idea behind the early asylum movement in the United States and in Europe was that mental illness could be treated, and that treatment required a specific kind of environment. The belief was that removing a troubled person from the stresses of ordinary domestic life, placing them in a calm, structured, and supervised setting, would allow their condition to improve over time. This was called moral treatment. It was considered progressive thinking in its moment. The asylum, under this framing, was a medical intervention, not a prison. The intention was recovery. At first, this explanation seems to account for most of what went wrong. Physicians made poor decisions because their science was poor. Commitment laws were broad because diagnosis was imprecise. Families were trusted because there was no reliable alternative. And when people like Elizabeth Packard ended up committed without justification, it was a failure of an imperfect system doing its best under difficult conditions. The tragedy, according to this reading, was real, but it was the tragedy of ignorance, not of deliberate harm. And ignorance, unlike deliberate harm, can be corrected over time as knowledge improves. The official explanation does not stop at describing the failures. It also points to their resolution. And this is the part of the account that carries the most weight in mainstream historical understanding. The laws did change. In the years following Elizabeth Packard's case, several states revised their commitment procedures. Requirements for medical examinations before commitment were introduced. Hearing processes were strengthened in some jurisdictions. The idea that a husband's word alone could be sufficient legal grounds for indefinite commitment became, over time, legally untenable in most parts of the country. The science also improved. Psychiatry developed clearer diagnostic frameworks. The moral treatment model was eventually replaced by more evidence-based approaches. The asylums of the 19th century were gradually replaced by different kinds of institutions operating under different standards. Under this explanation, Elizabeth Packard's case was not just a tragedy. It was, in a sense, a turning point. Her story, and the stories of others like her, contributed to legal reform. The system recognized its failures and corrected them. What happened to her could not happen today in the same way, under the same legal conditions, because those conditions no longer exist. The laws that made her commitment possible were dismantled. The doctrine of coverture was eventually abolished. The legal identity of married women was restored. The official account presents all of this as evidence that the system, while deeply flawed, was ultimately self-correcting. It made serious mistakes. It caused serious harm, but it acknowledged those mistakes and changed. That explanation is clean. It is organized. It does not require any part of the system to have been intentionally designed to harm specific people. It allows the failures to be understood as the natural result of a society operating with incomplete knowledge, and it allows the corrections to be understood as the natural result of that knowledge improving over time. There is no need, under this reading, to look for something more troubling beneath the surface. The surface itself, once examined historically, provides a sufficient account. But this is where it becomes unclear, because a self-correcting system, by definition, corrects itself when it detects its own errors. And the question that the official explanation does not fully address is what the error detection mechanism actually looked like in practice. If the system was simply suffering from ignorance, then the correction should have come from inside the system, from physicians and lawmakers identifying the flaws in their own procedures and revising them. But in Elizabeth Packard's case, and in many others from the same period, the correction did not come from inside. It came from the people who had been harmed by the system managing, against considerable legal obstacles, to force the system to hear them. Elizabeth Packard spent years after her release writing pamphlets, lobbying state legislatures, and campaigning for changes to commitment laws. She did not do this because the system had recognized its error and invited her input. She did it because the system had not recognized its error at all, and the only way to produce any change was sustained external pressure from someone who had personally experienced the harm. That is a meaningful distinction. A system that corrects itself when it detects errors behaves differently from a system that resists correction until the people it has harmed find a way to force it. Both systems might eventually arrive at the same legal reforms, but the path they take to get there raises different questions about what the system was actually designed to do. And this is where the explanation becomes difficult to hold in its original form. Because if the failures of the 19th century asylum system were primarily products of ignorance, you would expect the people operating the system to have been genuinely uncertain about the cases before them. Physicians who did not know how to diagnose mental illness accurately would make errors in both directions. Sometimes they would commit someone who was well. Sometimes they would release someone who was unwell. The errors would be distributed in a way that reflected genuine uncertainty. But the 7-minute jury verdict in Elizabeth Packard's case does not suggest that her condition was genuinely difficult to evaluate. 12 people who had not examined her, who had not known her before her commitment, reached a unanimous conclusion about her sanity in less time than it takes to eat a meal. That does not describe a case that was medically complex. Some researchers have pointed to this pattern as a problem for the ignorance explanation. If the physicians who committed patients like Elizabeth Packard were genuinely uncertain, their errors should have been harder to correct quickly once the legal process was finally allowed to proceed. But in case after case from this period, once a jury or a court was permitted to hear the evidence, the verdicts came swiftly. The confusion, it appears, was not about whether the person was mentally ill. The confusion, if it can even be called that, was about whether the person should be released. Those are not the same thing, and the difference between them is not easy to explain through ignorance alone. There is another element of the official explanation that deserves closer attention. The claim that the laws have since been corrected is accurate in a narrow legal sense. The specific commitment procedures of the 1860s no longer exist in the same form. Coverture was abolished. Women gained independent legal identity. Medical evaluation requirements were introduced into commitment law. All of that is true, but the claim that what happened to Elizabeth Packard could not happen today rests on an assumption that is harder to verify. It assumes that the legal reforms were thorough enough to close the specific gaps that allowed her experience to occur. That assumption has been questioned, not by everyone, but by enough researchers studying later periods of institutional history to make it a question worth holding onto rather than setting aside. The official explanation, taken as a whole, presents the 19th century asylum system as a medical project that was attempted with good intentions and failed because the science was not ready. It presents the legal framework surrounding that system as a reflection of social norms that have since evolved, and it presents the reforms that followed as evidence that the system was capable of recognizing and correcting its own flaws when given enough time. That account is available. It is the most common account, and it contains real elements of truth, but it leaves something unaddressed. It does not explain why the errors in the system so consistently produced the same kind of outcome, why the people who were harmed were so often people with limited legal access to begin with, why the corrections required sustained external pressure rather than internal recognition, and why, in case after case, the person who was harmed lost not just their freedom but also the material conditions, property, children, legal standing, that would have allowed them to fight back. Those are not questions that the ignorance explanation answers. They are questions that the ignorance explanation, if accepted too completely, prevents from being asked. That is the problem with a clean explanation. It resolves the discomfort before the investigation is finished. And in this particular case, the investigation is far from finished, because what the 19th century asylum system did to Elizabeth Packard is one part of a much larger and more complicated picture. The records that survive from this period contain details that the official explanation was not designed to accommodate, and some of those details raise questions that are considerably harder to set aside than the ones already examined. That is where this continues. There is a simple way to test whether a system is failing by accident or failing by design. Look at the direction of the errors. A system that fails because of genuine ignorance or limited knowledge produces mistakes that go in multiple directions. Sometimes the error harms one party. Sometimes it harms another. The failures are inconsistent because the underlying cause is uncertainty, and uncertainty does not favor anyone consistently. But a system whose errors repeatedly harm the same kind of person and repeatedly benefit the same kind of person raises a different question entirely, because that pattern is difficult to produce by accident over a long period of time. The 19th century asylum system, according to the official explanation, was a system failing from ignorance. Physicians did not have reliable diagnostic tools. Courts did not have a better source of information than family testimony. The commitment process was imprecise because the science was imprecise. All of that has been examined already, but what the official explanation does not fully address is the direction of the errors. If the system was genuinely uncertain, its mistakes should have scattered. A woman committed without justification here. A man kept too long there. A wealthy patient trapped. A poor patient released too early. The errors should have been distributed in a way that reflected the randomness of ignorance operating across a large population. But that is not what the records show. The records show something more specific. They show a pattern, and the pattern runs in one direction with a consistency that is difficult to attribute entirely to chance. The people who were harmed by the errors of this system were not a random cross-section of the population. They were, with striking regularity, people who already had limited access to legal recourse, people whose ability to challenge what was being done to them was constrained before the asylum became part of the picture. And the people who benefited from those errors, the people who came away from the situation with more than they had before, were the ones who had initiated the commitment process in the first place. That asymmetry is worth examining carefully. Elizabeth Packard's case is useful here not because it is exceptional, but because it is well documented. When she was released from Jacksonville Asylum after 3 years, she returned to her home in Illinois. The word returned is almost misleading. She came back to an address. What had been there was gone. The night before her release, her husband had rented the house to strangers. He had sold the furniture. He had emptied the bank accounts. He had gathered her wardrobe, her personal correspondence, her written notes, and her children. Then he left Illinois entirely. By the time Elizabeth arrived at her own front door, she was standing in front of a house that no longer contained any trace of the life she had been removed from 3 years earlier. At first, this seems like the action of a man who knew he had done something wrong and was trying to escape accountability. But this is where it becomes unclear, Because what Theophilus Packard did in those final hours, before his wife's release, was not a crime. It was not a violation of any law. It was not even, strictly speaking, a betrayal of any legal obligation he held toward her. Every action he took was entirely permitted under the legal structure of the time. And the reason it was permitted comes back to a doctrine that has already been mentioned, but deserves a much closer look. Coverture was not a minor or obscure legal provision. It was the foundational principle governing the legal relationship between a husband and wife in the United States and, before that, in English common law. The doctrine was simple in its construction and total in its effect. When a woman married, her legal identity did not merely change. It effectively ceased to exist as a separate entity. Her legal existence merged into her husband's. She did not lose some rights or have some rights restricted. She lost the legal capacity to act independently in almost every meaningful area of life. Under coverture, a married woman could not sign a contract in her own name. She could not open a bank account that was legally hers alone. She could not file a lawsuit or be named as a plaintiff in legal proceedings. She could not write a will without her husband's consent, because the property she might have wished to leave to someone was not, in the eyes of the law, hers to distribute. Any wages she earned from work belonged to her husband. Any property she brought into the marriage transferred to him. Any inheritance she received became his. And the children born within the marriage were legally his children, not hers. Her connection to them was biological and emotional. It was not legal. That detail sounds minor at first, like a legal technicality from a distant era, with no real teeth in practice, until it is examined more closely. Because coverture was not a rarely invoked technicality. It was the operating framework within which every married woman in the country lived. It was the legal reality of her daily existence. And when you place the asylum commitment laws of the 1860s directly alongside coverture, something becomes visible that is harder to explain as coincidence. The two systems together did not simply overlap. They created a sequence with no exit point. A husband could have his wife committed without a hearing, without an independent medical evaluation, and without presenting evidence to a court. That was the commitment law. Once she was inside the asylum, she had no independent legal identity with which to challenge the commitment. She could not hire an attorney in her own name. She could not file paperwork that the court was obligated to treat as coming from a legal person with standing. She could not act. That was coverture. And while she remained inside, unable to act, the person who had committed her retained full legal control over everything that had been hers. The house, the money, the furniture, the children. He could sell it, rent it, spend it, or take it across a state line. Legally, it was all already his. Coverture had settled that question before the asylum ever became relevant. This is where the explanation becomes difficult, because if these two systems, the commitment law and the doctrine of coverture, had been designed independently of each other to serve unrelated purposes, and had simply happened to align in a way that produced this particular outcome, you might still call it a product of historical coincidence. But the alignment is so complete, and the outcome it produces is so consistent, that the coincidence explanation requires more work than it might initially seem. The asylum removed the person. Coverture ensured there was nothing to return to and no legal mechanism available to fight back. Together, they produced an outcome that neither system could have produced alone quite so efficiently. Some historians are cautious about drawing direct lines between legal systems that developed separately and were administered by different institutions. The commitment laws were largely a medical and judicial matter. Coverture was a property and contract law matter. They were not designed in the same room by the same people at the same moment. That is a fair point. But the question of whether two systems were consciously designed to work together is different from the question of whether they did work together consistently to produce a specific kind of outcome. The first question is about intention. The second is about effect. And the effect, in case after case, was the same. The question that this raises is not whether Theophilus Packard was a particularly calculating man who had planned every detail in advance. It is a broader question about the structure he was operating within. He did not need to be unusually clever or unusually cruel to do what he did. The legal system handed him every tool he used. He needed to know one thing, that his wife's absence created an opportunity, and that the law would not prevent him from taking it. Whether he understood the full legal mechanics of coverture in detail is almost beside the point. The system did not require him to understand it. It simply worked in his favor while she was gone. And here is what makes that pattern significant beyond the individual case. Theophilus Packard was not the only husband who used this sequence. The records from the period, where they survive in enough detail to examine, show other cases with recognizable similarities. A wife committed, a husband with access to her property during the commitment, a return to a situation that had been significantly altered in her absence. The specifics varied, the general shape did not, and a pattern that repeats across multiple cases, across different states and different years, is harder to explain as a series of individual coincidences than as an indication of how the system actually operated for the people inside it. The word beneficiary is a useful one here. In any situation where something changes hands, whether it is property, money, legal standing, or physical freedom, the question of who benefits from that change is worth asking. In Elizabeth Packard's case, the answer is not complicated. Her husband walked away from 3 years of her institutional confinement with a house, furniture, money, her personal papers, and the children. She walked away with none of those things, and no legal mechanism to recover them. One party benefited significantly. The other lost everything recoverable. That is not ambiguous. What remains unclear is whether the system that produced this outcome was designed to produce it, drifted into producing it, or simply permitted it without ever examining the pattern carefully enough to notice. That last possibility is worth sitting with. A system does not have to be consciously designed to harm specific people in order to do so consistently. It is possible to build a legal framework that produces a particular outcome without any single person intending that outcome. The individual components, the commitment law, the coverture doctrine, the absence of legal representation for the committed person, can each have their own stated purpose and still combine to produce something that none of their designers explicitly planned. But that possibility does not resolve the question. It shifts it, because if a system consistently produces a harmful outcome for a specific population, and the people operating that system can observe the pattern over time without changing it, then the absence of explicit design becomes harder to separate from a form of tacit acceptance. The records that survive from this period are not complete enough to answer that question with certainty. What they are complete enough to show is the pattern itself, case after case in which the structure of the law created an exit for one party and no exit for the other. And the question of whether that pattern was designed, tolerated, or simply never examined carefully enough is one that the official explanation, with its focus on ignorance and eventual correction, does not fully address. It is a question that the records raise without answering, and it is a question that becomes considerably more difficult to set aside when the same pattern begins to appear in entirely different contexts, with entirely different populations, across a much longer stretch of time than Elizabeth Packard's individual story covers. To understand how a system capable of doing what it did to Elizabeth Packard could exist inside a functioning legal society, it helps to step back from the individual case and look at the broader legal environment surrounding it, because the asylum commitment laws of the 1860s did not operate in isolation. They existed inside a much larger framework, a framework that had been built over centuries, that was taught in law schools, administered in courtrooms, and applied in everyday transactions across the country. And once that framework is examined clearly, the asylum commitment laws begin to look less like an anomaly and more like a natural extension of something that was already fully in place. The doctrine at the center of that framework was called coverture. The word itself comes from the French, referring to something covered or sheltered. In legal practice, it meant something specific and total. When a woman married, her legal identity was covered by her husband's. She did not retain a separate legal existence alongside his. She did not hold a modified or reduced version of her prior legal standing. Her independent legal identity, for practical purposes, ceased to function. It merged into his, and that merger was not a metaphor. It had concrete, enforceable consequences in virtually every area of law that touched daily life. Coverture was not an American invention. It arrived with English common law and took firm root in the legal systems of the colonies, and then the states. By the time Elizabeth Packard was born in 1816, Coverture had already been the operating legal reality for married women in this country for generations. It was not a new or contested idea in the 1860s. It was not a law that reformers were actively challenging in mainstream legal circles at the moment Elizabeth's husband walked into the commitment process. It was simply how marriage worked, legally speaking. It was the background assumption that every court, every contract, and every property transaction involving a married woman operated against. Under coverture, a married woman could not own property separately from her husband. Property she brought into the marriage became his. Property she inherited during the marriage transferred to him. If she worked and earned wages, those wages belonged to him legally, not to her. She could not open a bank account in her own name that he did not have full access to and control over. She could not enter into a contract independently, which meant she could not rent a property, start a business, or make any legally binding agreement without him. She could not sue anyone in court or be named as a defendant in her own right. Legal proceedings involving her were conducted through him, and the children born within the marriage were, under the law, his children. Her relationship to them was not recognized in legal terms as giving her independent parental rights. That detail sounds minor at first, in the sense that most people would assume a mother's connection to her children was beyond legal interference, until it is examined more closely. Because what coverture meant in practice was that a father's decision about the children, where they lived, who raised them, whether they were kept or sent away, carried legal weight that a mother's decision simply did not. She had no independent legal standing from which to challenge his choices about the children, any more than she had standing to challenge his choices about the furniture or the bank account. The law did not recognize her as a separate party whose interests needed to be weighed. This was not hidden or spoken about in whispers in the 1860s. It was not a controversial legal interpretation that some judges applied and others rejected. It was the settled, publicly understood law of marriage. Legal texts explained it plainly. Lawyers trained in it. Judges applied it routinely. The people entering marriages in this period understood, at least in general terms, that this was the legal structure they were entering. Whether they agreed with it or found it troubling or simply accepted it as the way things were is a different question. But its existence was not a secret. It was simply how the law worked. Now place the asylum commitment laws directly alongside that structure. A husband, in Illinois in 1860, could have his wife committed to an asylum on his testimony alone. No independent medical examination was required before the commitment. No hearing was held at which the wife could present her own account or challenge her husband's claims. No evidence beyond his word needed to be produced. The law treated his testimony as sufficient, and so the commitment process began and ended with him, legally speaking, before anyone else's assessment of his wife's condition was considered necessary. But this is where it becomes unclear in a specific and important way. The commitment law on its own might be explained as a product of limited medical knowledge and excessive trust in family authority. That explanation has been examined already. What the explanation does not account for is what happened the moment the commitment was complete, because at that point, coverture took over, and coverture ensured that the woman who had just been committed had no independent legal mechanism available to challenge what had been done to her, regardless of how clearly she understood her situation or how strongly she wished to fight it. She could not hire an attorney in her own name. She had no legal standing to enter into the contract that hiring an attorney would require. She could not file paperwork with a court in her own right, because coverture did not recognize her as a legal person with the standing to initiate proceedings. She could not write letters to legal authorities that carried the weight of correspondence from someone the law recognized as an independent party. She could not appeal to the financial resources that might have allowed her to access legal help, because those resources, even if she had brought them into the marriage, were now legally his. She had no point of entry into the legal system that did not pass through the person who had committed her. Some researchers, when confronted with this alignment, argue that it should be understood as two separate systems, each a product of its era, that happened to interact in an unfortunate way. Coverture was a property and contract law matter. Commitment law was a medical and judicial matter. They were developed by different people, administered by different institutions, and addressed to different problems. The fact that they combined to produce a situation with no exit for the committed person was, under this reading, an unintended consequence rather than a designed feature. Both were simply products of their time. That argument is available, and it is not entirely without merit. Legal systems are rarely designed as unified wholes, with every interaction between their parts carefully planned. Laws accumulate over time, drafted by different people responding to different pressures, and the ways they interact are not always fully visible to the people writing them. It is possible to build a legal environment that produces a specific harmful outcome without any single legislator or judge explicitly intending that outcome. That possibility exists and should not be dismissed entirely. However, the timeline does not fully match the explanation of simple historical coincidence. Coverture was not a new law in the 1860s. It had been in place, in recognizable form, for centuries before Elizabeth Packard was committed. The commitment laws that existed in Illinois in 1860 were written and passed by legislators and legal professionals who operated entirely within the coverture framework. They were trained in it. They practiced in it daily. They understood, at some level of professional knowledge, that a married woman had no independent legal standing. And they wrote commitment laws that placed the authority to commit entirely in the hands of the person whose legal dominance over the woman was already total. That alignment may have been unintentional, but it is difficult to argue that it was unforeseeable to the people who wrote those laws. This is where the explanation becomes difficult to maintain in its simplest form, because foreseeability is different from intention, but it is also different from pure accident. If you write a law that gives one party total authority to remove another party from the legal environment, and you operate within a legal system that simultaneously ensures the removed party has no mechanism to resist or challenge that removal, and you are professionally trained in both systems, the question of whether you simply did not notice the interaction requires more than an assumption of ignorance to answer convincingly. Some historians have pressed on this point. Others remain cautious about attributing design to what might have been negligence. The disagreement itself has not been resolved. What can be said with more confidence is what the interaction of the two systems produced in practice. A woman could be removed from her home by the legal action of her husband, placed inside an institution, and left with no independent legal mechanism to challenge her placement, recover her property, maintain her relationship to her children, or access financial resources that had been hers before the marriage. Every door that might have allowed her to act was closed by one of the two systems. The Asylum commitment law closed the door on challenging the initial removal. Coverture closed every other door. Together, they produced a legal environment in which the person inside the asylum was entirely dependent on external intervention, someone outside the system choosing to act on her behalf, to have any hope of release. And external intervention was not guaranteed. It was not a standard part of the process. It required someone who knew the committed person, who had the legal standing and the financial means to act, and who was willing to challenge the authority of a husband whose word the law had already accepted as sufficient. In many cases, that person did not exist or did not act, and in those cases, what the two systems together produced was not a temporary mistake that the system would eventually self-correct. It was a permanent outcome, or as close to permanent as any outcome involving a living person can be. That is what makes the argument that both systems were simply products of their era difficult to accept as a complete answer. Products of their era can still be examined for what they produced and for whom. And what these two systems produced, together and consistently, was a specific outcome for a specific population. The people on the wrong side of that outcome were, with very little variation, people who already had the least legal standing, the least access to financial resources, and the least ability to access external intervention. That pattern does not resolve cleanly into coincidence, but whether it resolves into design is a question the available records do not answer with certainty. What they do is make the question harder to set aside the further into the evidence you go. Sometimes the most revealing documents are not the ones that were meant to be examined closely. They are the ones that were kept for administrative purposes, filed away in institutional records, and largely forgotten until someone thought to look at them generations later. The logbook from the West Virginia Hospital for the Insane is one of those documents. It was not created as evidence of anything. It was a routine administrative record, the kind of paperwork that institutions kept to track their population and justify their operations. But what it recorded, entry by entry across 25 years, raises questions that routine paperwork was never meant to raise. In 1993, a historian named Marjorie Carr compiled that log book into a pamphlet. The original record had been kept at the West Virginia Hospital for the Insane at Weston, and it covered admissions from October 1864 through December 1889. That is a span of 25 years. Every patient admitted during that period was recorded in the log, along with the stated reason for their commitment. Carr's compilation of that material was eventually archived at the West Virginia Division of Culture and History, where it remains available to researchers. The document itself is not difficult to locate. What is more difficult is knowing what to do with what it contains. The log records 125 different reasons for commitment across that 25-year period. Some of them are recognizable as medical observations, however imprecise by modern standards. Some refer to physical conditions that physicians of the era believed could affect mental stability. Those entries, while limited in their diagnostic value, at least gesture toward a clinical framework of some kind. But others are harder to place within any medical framework, however generous your interpretation of 19th century psychiatric practice. And it is those entries that have drawn the most attention from researchers and historians who have examined the document in the decades since Carr compiled it. The list includes laziness. It includes novel reading. It includes hard study. It includes political excitement, religious enthusiasm, disappointed love, and jealousy. It includes snuff eating for 2 years. It includes imaginary female trouble. It includes domestic trouble. These are the entries that, when the document first came to wider public attention, prompted significant discussion about what they actually meant and what they actually represented within the context of the institution that produced them. The range of what appears on that list is wide enough that almost any behavior or circumstance could find a place somewhere within it. In 2016, Snopes investigated the document and confirmed that it was authentic. The entries were real. The log was a genuine historical record, not a fabrication or an exaggeration produced after the fact. But Snopes also added a clarification that has become the standard framing for how the document is discussed. The entries, according to that clarification, were recorded as supposed causes of insanity, not as formal diagnoses in themselves. The physicians of the time apparently expressed in their own records some degree of unease with the categories. So the standard interpretation that emerged was that these entries represented contributing factors, environmental or behavioral circumstances that the physicians of the era believed might trigger or worsen an underlying mental condition, rather than standalone justifications for commitment on their own terms. That interpretation is technically defensible. It is the most careful and historically grounded reading of what the entries were meant to represent within the medical thinking of the period. Physicians in the 19th century did believe that environmental stressors could precipitate mental illness in people who were already vulnerable to it. Overwork, grief, emotional disappointment, excessive reading, religious fervor. These were things that the medicine of the time considered relevant to mental health in ways that, while different from modern frameworks, were not entirely without internal logic. So the argument that these entries were contributing factors rather than sole causes has a basis in the medical literature of the era. But this is where it becomes unclear, because the contributing factor explanation only works if there was an independent assessment of the underlying condition that the contributing factor was supposedly triggering. For the entries to represent legitimate medical reasoning, the physician receiving the patient would need to have independently evaluated whether a genuine mental illness was present, and then recorded the supposed environmental cause alongside that independent assessment. The contributing factor would be one part of a two-part record. The underlying diagnosis would be the other. But the logbook does not consistently show that two-part structure. What it shows in many entries is the stated cause alone, without a clearly documented independent clinical assessment of the kind that would give the contributing factor explanation its necessary foundation. The reason recorded in the log was, in a significant number of cases, the information provided by the person who brought the patient in, the husband who described his wife's behavior, the family member who reported on a relative's conduct, the official who documented a person's refusal to comply with certain expectations, and in most cases, There was no independent verification required before that information was accepted and the commitment was processed. That detail sounds minor at first. Record-keeping in the 19th century was imprecise across many institutional settings. Physicians were overworked. The administrative infrastructure of asylums was limited. Missing documentation does not automatically mean that evaluations were not conducted until it is examined more closely in the context of what the commitment process actually required legally, because the commitment laws of the period, as already established, did not mandate independent medical evaluation before admission in most states. A family member's testimony was sufficient. The physician at the receiving institution might conduct their own assessment after the patient arrived, but that assessment came after the commitment had already been made, not before it, and the logbook entry, which recorded the cause of the commitment, reflected what had been reported at the point of admission, not necessarily what a physician had independently concluded afterward. This creates a significant problem for the contributing factor explanation. If the entries in the log represent what the person initiating the commitment reported as the cause, then the medical framing, the idea that these were clinically considered environmental triggers, is applied after the fact to justify what was already a socially and legally determined outcome. The husband who said his wife was suffering from domestic trouble was not providing a clinical observation for a physician to evaluate. He was providing the reason for the commitment, and the commitment proceeded on that basis. The physician's role, to whatever extent it existed, came after the determination had effectively already been made. Some researchers are cautious about pressing this point too far. It is possible, they note, that the physicians at these institutions did conduct independent evaluations that are not fully reflected in the logbook entries as they were recorded. Administrative records are summaries, not transcripts. They do not capture every conversation or every clinical judgment that occurred in the process of admitting a patient. The absence of documented independent assessment in the log does not prove that no assessment occurred. That is a fair point, and it limits how firmly any conclusion can be drawn from the log alone. However, the timeline does not fully match the explanation that independent clinical judgment was the primary driver of these commitments. If physicians were genuinely evaluating each patient independently and recording the environmental factors as secondary context, you would expect the range of recorded causes to cluster around recognizable clinical categories, even imprecise 19th century ones. You would expect the entries to reflect the language of the medical literature of the period. But the list includes entries like domestic trouble and imaginary female trouble that do not map cleanly onto any clinical category, even a generous interpretation of 19th century psychiatric thinking. Those entries read less like clinical observations and more like descriptions of social situations reported by the people initiating the commitment. The entry for domestic trouble is worth pausing on specifically. That phrase does not describe a symptom. It does not describe a behavior. It does not describe a physical or psychological condition that a physician could observe or evaluate. It describes a situation in a household, and a situation in a household could mean almost anything. It could mean conflict between spouses. It could mean a woman expressing unhappiness with her circumstances. It could mean a refusal to perform certain domestic responsibilities. It could mean nothing more specific than that the person reporting it found their home life inconvenient in some way that they chose to describe in those terms. The vagueness of the entry is not incidental. It is built into the language itself, and that vagueness raises a question that the contributing factor explanation does not fully address. If the purpose of recording the cause of commitment was to document a clinical observation that would guide treatment, precise language would serve that purpose better than vague language. A physician who needed to understand a patient's condition in order to treat it would benefit from specific information. But if the purpose of recording the cause was simply to justify the commitment that had already been initiated, then vague language serves that purpose equally well, possibly better, because it is harder to challenge. Domestic trouble is not a claim that can easily be proven false. It describes a subjective situation in private space that only the reporting party had full access to. This is where the explanation starts to weaken in its most important dimension. The standard reading of the logbook treats the entries as imprecise, but genuine attempts at medical documentation within the limited scientific framework of the time. That reading is offered in good faith and is not without support, but it assumes that the entries primarily reflect the clinical judgment of the receiving physicians and the structure of the commitment process, as it actually operated legally in most states during this period, does not support that assumption. The entries primarily reflect what was reported by the person initiating the commitment. The physician's role was, in many cases, to receive that report and process the admission, not to independently determine whether the report was accurate before the commitment occurred. What the logbook shows, when examined against the legal structure that produced it, is not primarily a record of medical assessment. It is a record of reported causes, and reported causes are only as reliable as the process used to verify them. In this system, that process did not include independent verification, a second opinion, a hearing, or any legal mechanism through which the person being committed could challenge what was being reported about them before the commitment was complete. The word of whoever brought the patient in was the foundation on which the entry was built, and the entry, once written into the log, became the official record of why that person was there. That gap between what the document appears to be and what the process that produced it actually was is not a small one. It does not close easily under the contributing factor explanation, and it does not sit comfortably alongside the broader claim that the system was doing its best within the limits of its knowledge, because knowledge was not what was missing from the verification process. A hearing does not require advanced psychiatric science. A second opinion does not require modern diagnostic tools. What the process was missing was not scientific capacity. It was a mechanism that gave any weight at all to the account of the person being committed, and that absence is harder to explain as a product of limited knowledge than as a product of a system that was not designed to hear that account in the first place. There is a particular kind of document that reveals more about a system than its authors intended, not because it contains hidden information or coded language, but because it states its reasoning plainly and without apparent awareness that the reasoning itself is the problem. The paper that Samuel Cartwright presented to the Medical Association of Louisiana in 1851 is that kind of document. It does not hide what it is doing. It explains it clearly, in the professional language of 19th century medicine, with citations and terminology, and the structural confidence of a man addressing his peers at an annual meeting. And that is precisely what makes it so difficult to explain away as a simple product of its time. Samuel Cartwright was not a fringe figure in American medicine in 1851. He was a physician who had spent decades practicing in the South, who had built a professional reputation, and who held a position of institutional authority within the medical establishment of his region. When he presented his paper to the Medical Association of Louisiana, he was doing so as the chairman of a committee specifically formed to investigate the diseases and physical peculiarities of the Negro race, as the committee's own language described it. He was not an outsider proposing a radical idea to a skeptical audience. He was an institutional representative delivering findings to a body that had commissioned the work. The paper described what Cartwright called a newly identified mental illness. He gave it the name drapetomania. The construction of the word was deliberate. It combined two Greek roots. The first referred to a runaway slave. The second referred to madness. Together, they named the condition Cartwright believed he had identified. And the condition was this: the desire of an enslaved person to escape from captivity. That desire, according to Cartwright's paper, was the symptom, the act of attempting to run away, or even the persistent inclination toward it, was evidence of a diagnosable mental illness. The reasoning Cartwright offered to support this conclusion is worth examining carefully, because it follows a specific internal logic that is important to understand. His argument was not simply that enslaved people who ran away were mentally disturbed in a general sense. His argument was more structured than that. He began from the premise, stated as fact in his paper, that slavery was a natural and beneficial condition for the people held within it. Given that premise, the desire to escape from it became puzzling. A person who wanted to leave a situation that was genuinely good for them, who persistently sought to remove themselves from conditions that served their well-being, was behaving irrationally. And irrational behavior, in the medical framework of the period, was a symptom of mental illness. The diagnosis followed, in Cartwright's presentation, as a logical conclusion from the premise. But this is where it becomes unclear, because the entire diagnostic structure rests entirely on the premise. If slavery was not a natural and beneficial condition, then the desire to escape it was not irrational, and the diagnosis collapsed immediately. Cartwright's medical argument was not actually a medical argument. It was a political and ideological claim dressed in medical language. The premise was not a clinical observation. It was a social position. And once the premise is identified as a social position rather than a medical finding, the diagnosis it produces cannot be evaluated as medicine. It can only be evaluated as ideology. That distinction matters because it is not a distinction that Cartwright's paper draws. The document presents the premise and the conclusion in the same clinical register, using the same professional vocabulary, without flagging the premise as the kind of assumption that requires independent support before the diagnostic reasoning can proceed. To a reader who accepted the premise, the diagnosis would appear to follow logically. To a reader who did not accept the premise, the entire structure would appear as something other than medicine. The paper's persuasive force depended entirely on whether its audience shared its starting point. The prescribed treatment that Cartwright recommended for drapetomania was whipping. He described this not as punishment but as medical intervention, a corrective measure designed to address the underlying condition that was causing the patient to seek escape. For severe cases, where the inclination toward running away was persistent and resistant to earlier treatment, Cartwright recommended a more permanent solution. He proposed amputating both of the patient's big toes. The reasoning was functional. Without the full use of their feet, the patient would be physically incapable of the sustained running that escape required. The medical intervention would remove the symptom by removing the physical capacity to act on it. The document in which these recommendations appeared was not an obscure private communication. It was published in Debo's Review. Debo's Review was one of the most widely read publications in the American South during this period. It covered commercial, agricultural, and economic topics alongside political and social commentary, and it reached a substantial readership of educated Southern professionals. Cartwright's paper was not placed in a specialty medical journal with a limited audience. It was placed in a mainstream publication where it would be read by people who were not necessarily physicians, but who were part of the social and economic structure that the paper was addressing. At first, it seems like a case study in how badly wrong scientific thinking can go when it is shaped by ideology rather than evidence. Northern publications did respond critically at the time. Some mocked the diagnosis openly. Frederick Law Olmsted, the landscape architect who later designed Central Park, wrote a satirical response pointing out that if the desire to escape captivity was a mental illness, the disease must have European origins, since white indentured servants had also consistently attempted to flee their masters. The critique was sharp. It identified the logical problem with the diagnosis clearly and publicly, and the criticism was not invisible. It circulated. People read it. But this is where the timeline does not fully match the explanation of simple ignorance that is usually offered for cases like this. If the diagnosis was widely recognized as flawed even at the time of its publication, if critics had publicly identified the logical error in its construction within years of its appearance, then the expected outcome would be for the term to fade from professional use as the criticism accumulated. Discredited ideas do not always disappear immediately, but they tend to lose their standing in professional reference material over time as the field moves past them. That is the normal trajectory of a medical concept that fails to hold up under scrutiny. Drapetomania did not follow that trajectory. The term appeared in Stedman's Practical Medical Dictionary. That was not a fringe publication. It was a mainstream professional reference, work used by practicing physicians across the country. And drapetomania remained in that dictionary through its third edition, which was published in 1914. More than 60 years after Cartwright presented his paper, more than 60 years after Northern critics had publicly identified its logical failures, the term was still listed in a standard professional medical reference as a legitimate category. It had not been removed. It had not been flagged as discredited. It was simply there, in the same volume with other medical terminology, available to any physician who consulted the dictionary for professional reference. That detail sounds minor at first, like a clerical oversight in a large reference work that simply had not been updated carefully enough, until it is examined more closely, because Stedman's Practical Medical Dictionary was not a historical archive. It was a professional tool intended for active clinical use. Its entries were not preserved as historical curiosities. They were included because the editors of the dictionary considered them relevant to contemporary medical practice. The continued presence of drapetomania through 3 editions of that dictionary, spanning decades, during which the term had been criticized publicly and the institution it was designed to defend had been legally abolished, raises a question that the clerical oversight explanation does not answer satisfactorily. How does a term that was recognized as ideologically constructed rather than clinically grounded remain in a professional medical reference for more than 6 decades? One possibility is that the editors simply did not review every entry with sufficient care. Reference works of that size do contain errors of omission and outdated material. That is a real phenomenon, but it does not fully account for the specific case of a term whose ideological basis had been publicly identified and whose underlying premise, that slavery was a natural and beneficial condition, had been not just criticized, but legally resolved by the abolition of slavery itself in 1865. The institution the diagnosis was designed to serve had ceased to exist legally 50 years before the 3rd edition of the dictionary appeared, and the term was still there. Another possibility is that the term's continued presence reflects something about how medical legitimacy actually works, which is different from how it is usually described. The official account of medical progress presents the field as self-correcting, moving steadily away from ideologically contaminated ideas toward evidence-based practice as the science improves. Under that account, drapetomania should have been removed from professional reference material relatively quickly, once its ideological basis was identified. The fact that it was not raises questions about whether the self-correction mechanism in medicine operates as reliably as the official account suggests, particularly when the ideas in question align with social and political interests that extend beyond the medical field itself. This is where the explanation becomes difficult in a way that goes beyond the specific case, because drapetomania is useful not just as an example of how wrong medical thinking can go, but as a case study in how medical language can be used to give institutional legitimacy to social and political positions. The diagnosis did not simply make a medical error. It performed a specific social function. It took the desire for freedom, which is not a symptom of anything in any clinical framework, and reframed it as evidence of illness. That reframing allowed a social control mechanism, the forcible return of people who had escaped captivity, to be described in medical rather than purely coercive terms. The physician treating the patient was not enforcing a social hierarchy. He was addressing a medical condition. The language changed what the action appeared to be, even when the action itself remained the same. That function, using medical or institutional language to reframe coercive action as care or treatment, is not unique to Cartwright's paper. It appears in other contexts during the same period and in later periods as well. The specific diagnoses change. The populations they are applied to change, but the structure, defining the resistance of a specific group to a specific set of conditions as a symptom of illness, appears in recognizable form across more than one context in this history. Whether those appearances represent a connected pattern or a series of independent coincidences shaped by similar social pressures is a question that researchers have not fully resolved. Some believe the pattern is clear. Others argue that each case must be understood within its own specific historical context before comparisons are drawn. What can be said is that the 1914 dictionary entry for drapetomania does not sit comfortably alongside the explanation that the failures of this period were simply products of limited medical knowledge. Limited knowledge produces errors that are corrected as knowledge improves. The criticism of drapetomania was available. The abolition of the institution it was designed to serve had occurred. The knowledge needed to remove the term existed, and the term remained. That gap between what should have happened under the self-correction model and what actually happened is not fully explained by ignorance. It requires a different kind of account, and what that account looks like is not yet entirely clear. When a system produces a harmful outcome, one of the most common explanations offered is that the system was under stress. It was overwhelmed. It was operating in difficult conditions that it was not designed to handle, and under enough stress, even a well-designed system can produce results that its designers never intended. That explanation is reasonable in many cases, but it depends on one thing being true. The harmful outcome should diminish when the stress diminishes. When conditions improve, the errors should reduce. If the harm continues or expands even as conditions change, the stress explanation begins to lose its footing. The Civil War ended in April 1865. The legal institution of slavery was abolished by the 13th Amendment later that same year. 4 million people who had been held in captivity were legally free for the first time. The social, economic, and political upheaval of that moment was enormous. There were legitimate reasons to expect that institutions across the country would need time to adjust to conditions that had no real precedent. And so, if the asylum system had expanded its reach into the newly freed black population during the immediate post-war years, and then gradually corrected course as the society stabilized, that might be explained, at least partially, as a system under exceptional stress, producing outcomes it would later recognize and address. But the pattern did not correct course. It expanded, and it expanded not into a temporary or emergency framework that would later be dismantled, but into permanent institutional structures that persisted, in some cases, for nearly a century after the war ended. That timeline is one of the first things that makes the stress explanation difficult to maintain. A response to temporary upheaval does not typically produce permanent segregated institutions that operate under conditions researchers later describe as indistinguishable from the forced labor system that preceded them. To understand how this happened, it helps to go back slightly before the war ended, to a piece of data that was produced 25 years earlier and that shaped the post-war response in ways that are important to understand. The 1840 United States Census included statistics on mental illness in the American population. Among its findings was a claim that attracted significant attention at the time. The census reported that free black Americans living in northern states had an insanity rate approximately 10 times higher than enslaved people living in the South. 10 times higher. That is not a marginal statistical difference. It is a number that, if accurate, would represent a profound and unusual public health phenomenon demanding serious investigation. The data was used immediately for political purposes. John C. Calhoun, who served as Secretary of State, cited those census figures in a formal diplomatic communication in 1844 as evidence that freedom itself was mentally destabilizing for black Americans. His argument was explicit. The data, he contended, demonstrated that the condition of slavery was protective of mental health, and that removing people from that condition exposed them to psychological deterioration they could not withstand. The census figures, and Calhoun's use of them, became a political argument against emancipation framed in the language of public health and statistical evidence. But this is where it becomes unclear, because the data was wrong. Not imprecise in the way that all census data from that era was imprecise, not subject to the kinds of measurement errors that affect any large-scale statistical effort, wrong in ways that were specific, directional, and difficult to attribute to ordinary administrative error. Researchers who examined the 1840 census figures found entries that were, by any straightforward reading, impossible. Towns in northern states that had no black residents recorded at all were listed as having dozens of black patients in mental institutions. Communities where black populations were small and documented were reported as having insanity rates that exceeded their entire recorded population in some categories. The errors did not scatter in multiple directions. They consistently inflated the numbers in one direction, upward, in the states and regions where the political argument being constructed from them required the numbers to be high. Edward Jarvis, a physician and statistician, investigated the 1840 census figures shortly after they were published and documented the errors in detail. His findings were presented to the American Statistical Association, which formally protested the census to Congress. The errors were acknowledged. The methodology was criticized, and the census was not corrected. The official figures remained on record, available for citation, and continued to be cited by those who found them useful. That is the detail that sits most uncomfortably within the explanation that this was simply an administrative failure. Administrative failures, when identified and formally protested through official channels, are typically corrected in the official record. This one was not. The 1840 census data matters to what came after the war because it established, in official statistical form, a framework for understanding black mental health that preceded emancipation and outlasted it. When 4 million people became legally free in 1865 and began navigating life outside the institution of slavery, the existing public discourse already contained a statistical argument, fraudulent but officially uncorrected, suggesting that freedom itself was a health risk for this population. That argument did not need to be reconstructed after the war. It was already in the record, already cited in official government communications, already available as a framework through which the post-war situation could be interpreted by those who wished to use it that way. In 1870, 5 years after emancipation, Virginia opened an institution called the Central Lunatic Asylum for Colored Insane. It was the first institution in the United States specifically designated for African American patients. The timing is the first thing worth noting. The war had ended 5 years earlier. The legal basis for holding people in forced labor had been abolished, and Virginia responded, within that 5-year window, by opening a segregated mental institution specifically for the population that had just been legally freed. The proximity of those two events does not establish a causal connection by itself, but it is a detail that sits alongside the fraudulent census data and the Cartwright paper in a way that requires some account. Researchers who have examined the records of the Central Lunatic Asylum for Colored Insane found no evidence that any patient admitted to the facility had done so voluntarily. That is a striking finding. Voluntary commitment to mental institutions was not common in this period under any circumstances, but the complete absence of any voluntary admission in the records of this particular facility is a detail worth holding. It means that every person in that institution was there because someone with authority over them had placed them there. The nature of that authority, who held it and on what basis they exercised it, is not fully documented in the available records, but the outcome it produced was a population entirely composed of involuntary patients. The prescribed treatment at the facility was hard farm labor and domestic work. That detail sounds minor at first, given that labor-based therapies did exist within 19th century psychiatric thinking under the framework of moral treatment. The idea that structured work could contribute to mental recovery was a real element of asylum medicine during this period, until it is examined more closely alongside the specific context of this institution. The facility opened 5 years after the legal abolition of a system in which the same population had been compelled to perform agricultural and domestic labor under institutional authority. The form of treatment prescribed at the Central Lunatic Asylum for Colored Insane was, in practical terms, structurally identical to the system that had preceded it. The legal framework was different. The daily experience, as described in the available records, was not. The facility also suffered from severe overcrowding throughout its operation. Overcrowding in institutional settings produces predictable consequences. It strains sanitation infrastructure. It increases the transmission of infectious disease. It reduces the ability of staff to monitor individual patients. It creates conditions in which preventable deaths become common. The records of the Central Lunatic Asylum for Colored Insane reflect those consequences. A large percentage of patients died from diseases that researchers later identified as directly caused by the overcrowding conditions. These were not deaths from untreatable illnesses or from conditions that the medicine of the time was powerless to address. They were deaths from the predictable outcomes of overcrowding that persisted over time without being adequately addressed. And this is where the explanation becomes difficult, because overcrowding in an institution is a condition that administrators can observe. It is not a hidden problem. It produces visible consequences that anyone managing the facility would encounter in their daily operations. The question that the available records raise, without fully answering, is why the overcrowding was not addressed in a way that reduced the death rate. Resources were available for mental institutions in Virginia during this period. Other facilities received funding and attention. The explanation that resources simply did not exist does not fully account for the specific conditions documented at this particular facility. What the records show is a pattern of neglect that persisted, not a temporary emergency that overwhelmed an otherwise functioning system. Segregated mental health facilities for Black patients in Virginia did not end when the Civil War generation passed. They did not end when the 20th century began. They persisted through both world wars, through the New Deal, through the post-war period, through the early civil rights era. Segregated facilities for black patients in Virginia remained in operation until 1967. That is 102 years after the abolition of slavery. The institutional structure that opened 5 years after emancipation outlasted every major legal transformation of the intervening century, until it was finally addressed by civil rights legislation that made its explicit segregation legally untenable. That timeline raises questions that the stress explanation cannot answer. A system responding to the temporary disruption of emancipation would not have required a century to correct itself. The conditions that produced the Central Lunatic Asylum for colored and sane in 1870 did not persist unchanged for a century because the system was under stress. They persisted because the system was functioning as it had been constructed to function, serving the interests it had been constructed to serve, within a legal and social environment that did not require it to change until external legal pressure finally made continuation impossible. The mechanism that appears here is recognizable. It appeared in the Coverture cases. It appeared in the West Virginia Log Book. It appeared in Cartwright's paper. The specific population is different. The specific legal framework is different. The specific institution is different. But the structure is the same. A population with limited legal recourse is subjected to institutional authority on grounds that are framed in medical or administrative language. The institution prescribes conditions that resemble, in practical terms, what the population was subjected to before the institutional framework was created. The people inside have no effective mechanism to challenge their placement or the conditions they experience. And the institution persists, serving the interests of those who benefit from its operation, until something outside the system forces a change that the system itself showed no indication of producing on its own. Some researchers are cautious about drawing direct lines between these cases. Each has its own specific historical context. Each involves different actors, different institutions, and different legal environments. The caution is reasonable, but the pattern they describe, when examined across cases and across time, is consistent enough that it becomes difficult to account for entirely through a series of independent coincidences. Different population, different era, very similar outcome. That observation does not resolve into a final conclusion, but it does raise a question that becomes harder to set aside the further the evidence extends. Here is the fully expanded Chapter 8 script, approximately 2,430 words, continuous narration, no labels. There's a question that runs underneath all of the cases examined so far. It is not a question about any individual institution or any specific legal framework. It is a broader question about how institutional harm gets started in the first place. The cases involving women under coverture began with laws that already existed and were simply applied in a particular direction. The cases involving Black Americans after the Civil War began with fraudulent data that was used to justify a predetermined conclusion. But what about cases where neither an existing legal framework nor a manufactured statistical argument was available as a starting point? What happens when an institution is built from nothing, with no prior framework to draw on, and the building of it serves a purpose that has nothing to do with the population it is supposed to serve? That is the question the Canton case raises, and the answer it produces is one of the most difficult to set aside in this entire investigation. In 1902, the United States federal government opened a mental institution in Canton, South Dakota. It was the only federally funded mental institution in the country specifically designated for Native American patients. The fact that such an institution existed is not, on its surface, surprising. The federal government administered a wide range of programs directed toward indigenous people during this period, some nominally therapeutic, some explicitly coercive, many operating in the space between those two descriptions. A mental health facility for Native Americans could, in principle, have been a genuine attempt to provide care for a population that federal policy had systematically displaced and impoverished over the preceding decades. That is one way such an institution could have come to exist. But the circumstances of Canton's founding do not match that description. According to the historical record, the institution was not established in response to a documented mental health crisis among indigenous people. There was no survey of need. There was no medical study identifying a gap in services that the facility would address. There was no petition from indigenous communities requesting access to mental health care. The institution was established, according to the records of its founding, partly because two South Dakota congressmen saw an opportunity to direct federal funding and federal jobs toward their state. South Dakota was a new state in 1902. It had been admitted to the Union in 1889, carved directly out of territory that indigenous nations had inhabited and that had been taken through a combination of treaty violations, military force, and federal land policy. The state was still developing its economic infrastructure. Federal institutions meant federal money and federal employment. The congressmen wanted both. That is the founding context. A federal mental institution for Native Americans, built not because Native Americans needed it in any documented sense, but because two politicians in a struggling new state wanted the economic benefit a federal facility would bring. That detail sounds minor at first, the kind of political horse trading that shapes where federal projects land without necessarily affecting how they operate, until it is examined more closely, because the founding purpose of an institution shapes everything that follows. An institution built to serve a political and economic purpose, rather than a clinical one, does not have an internal mechanism that corrects course toward genuine care. It has a mechanism that serves the purpose it was built for, and that is what Canton did, consistently, for 30 years. Over the 3 decades that Canton operated, more than 350 Native Americans from tribes across the country were forcibly committed there. The geographic range of that commitment is itself unusual. A mental health facility serving a defined regional population would draw its patients from that region. But Canton received patients from tribes that had no particular connection to South Dakota, from communities located hundreds, and in some cases thousands of miles away. People were transferred to Canton from across the country, which raises a question about what the facility was actually functioning as. A regional care facility does not typically receive patients from every corner of a continent. A holding facility, one whose primary purpose is containment rather than treatment, does not need to limit its intake to a defined geographic region. The recorded reasons for commitment at Canton are among the most revealing details in its documented history. Some might expect, given the medical framing of the institution, that the reasons would at least gesture toward clinical observations, however imprecise. But the records show something different. The recorded reasons for commitment included refusing to follow government policies, practicing traditional spiritual ceremonies, being uncooperative with federal authorities. These are not medical observations. They are descriptions of political and cultural behavior. Refusing to comply with a government policy is not a symptom of mental illness under any clinical framework, including the imprecise frameworks of early 20th century psychiatry. Practicing a traditional ceremony is not a diagnosable condition. Being uncooperative with authorities describes a relationship between a person and an institution, not a state of mind that a physician can evaluate and treat. One entry in the records describes a man who was diagnosed with what the documentation calls horse-stealing mania. That entry is worth pausing on. Horse-stealing mania is not a medical term from any tradition of psychiatric practice. It is not a category from any diagnostic framework of the period. It appears to have been constructed specifically for this record, to describe this person, in terms that would justify his placement in a federal mental institution. The diagnosis tells you nothing about the man's mental state. It tells you something about what he was accused of doing and about the willingness of the people processing his commitment to use the language of diagnosis as a container for whatever information they needed to record in order to complete the paperwork. No interpreters were provided at Canton. That detail is important and easily overlooked. The patients committed to Canton came from tribes across the country, speaking a range of indigenous languages that were entirely distinct from English. Many of them had limited or no English language ability. A mental health institution that receives patients who do not share a language with its staff and provides no interpreters cannot conduct any meaningful clinical evaluation. It cannot take a patient history. It cannot explain a diagnosis or a treatment plan. It cannot obtain informed consent for any procedure. It cannot even establish basic communication about a patient's physical needs or complaints. The absence of interpreters was not a minor logistical oversight. It made any genuine clinical function at the facility essentially impossible from the moment a patient arrived. No mental evaluations were conducted on admission. This is the detail that, in a medical institution, should be the most difficult to explain. Whatever the limitations of early 20th century psychiatric practice, the field did have evaluation procedures. Physicians did conduct assessments. The process was imprecise by modern standards, but it existed. A mental health facility that does not conduct mental evaluations on admission is not functioning as a medical facility in any recognizable sense. It is functioning as a facility that receives and holds people. The evaluation, which in a genuine medical context would be the starting point of the patient's care, was simply absent. People arrived and were held without any documented clinical assessment of their condition. No therapeutic programs existed at the facility. This is where the explanation that Canton was a poorly run but genuine medical institution becomes very difficult to maintain. A mental health facility with no therapeutic programs is not a poorly run mental health facility. It is a facility that is not providing mental health care. Therapy in the early 20th century was limited and imperfect, but it existed in recognizable forms at institutions that were genuinely attempting to treat patients. The absence of any therapeutic programming at Canton was not a resource limitation or an administrative failure. It was a description of what the facility was. It held people. It did not treat them. Investigators who examined Canton during its operation described physical conditions that are difficult to characterize as anything other than deliberate neglect. Patients were shackled to beds. The facility was described in investigative reports as filthy. Patients were found lying in their own waste. These conditions were documented by people who visited the facility with the authority to report on what they found. The reports existed. They were filed. And the facility continued to operate for years after those reports were produced, which raises questions about what the investigative and reporting process was actually designed to accomplish if the conditions it documented were allowed to persist. At least 121 people died at Canton during its 30 years of operation. That number represents a significant proportion of the more than 350 people who passed through the facility, and the nature of those deaths adds another layer to the record. More than half of the people who died at Canton died from diseases that researchers later identified as entirely curable with the medical knowledge available at the time. They did not die from conditions that medicine could not address. They died from conditions that medicine could address, but that were not addressed in their cases. Overcrowding, malnutrition, inadequate sanitation, and the physical consequences of prolonged restraint produced illnesses that a functioning medical facility would have treated. Canton did not treat them. The testimony of indigenous elders adds a dimension to the Canton record that the institutional documents alone do not capture. Elders who were children during the period when Canton was operating have testified that children at federal boarding schools were explicitly warned about the facility. The warning was stated as a consequence. If you misbehave, you will be sent to Canton. The children who received that warning understood what it meant. Canton was not described to them as a place of care or treatment. It was described and understood as a place you did not come back from. The facility functioned as a threat in the disciplinary system of the boarding schools, which were themselves coercive institutions. One coercive institution was used to reinforce compliance within another. The threat was credible because the children who heard it had enough information about Canton to understand that the warning was not an exaggeration. When Commissioner of Indian Affairs John Collier finally ordered Canton closed in 1933, something happened that captures the nature of the institution more clearly than almost anything else in its documented history. Local residents of Canton, South Dakota, went to federal court to fight the closure. Their argument was not about the patients. No one who filed to keep Canton open argued that the people inside needed the facility to remain open for their care and treatment. The argument was economic. Canton was a major employer in the area during the Depression. Closing it would eliminate federal jobs and federal money flowing into the local economy. The residents who fought to keep it open were fighting to preserve an economic asset. The people inside the facility were not part of that calculation in any meaningful way. That final detail does not resolve into a clean conclusion, but it does clarify something about what Canton actually was. For 30 years, it held more than 350 people from indigenous nations across the country, committed on grounds that included practicing their own ceremonies and refusing to comply with federal directives, in a facility with no interpreters, no evaluations, no therapy, and conditions that killed more than 100 people from curable diseases. And when the question of whether it should continue operating was finally raised, the argument for keeping it open had nothing to do with the people inside. It was about the jobs. The institution had served its founding purpose consistently for 3 decades, and its founding purpose, as the record makes clear, had never been the care of the people it held. At some point in any investigation that spans multiple cases, multiple time periods, and multiple populations, a question becomes unavoidable. Are these cases connected, or are they separate events that simply share surface similarities? That question is not a small one. The answer changes everything about how the evidence is understood and what conclusions, if any, are possible. And it is a question that serious researchers and historians have approached from genuinely different directions, arriving at genuinely different answers. Both directions deserve to be examined carefully before either is accepted or dismissed. The first interpretation is the one that most mainstream historical accounts favor, at least in their basic structure. Under this reading, each case in this investigation belongs to its own specific historical moment, shaped by its own specific conditions, and is best understood within its own context rather than alongside the others. The asylum commitment laws of the 1860s were a product of a particular period in American legal and medical history, when commitment procedures were loosely defined and family authority was treated as a substitute for clinical judgment that the field was not yet capable of providing. The racial science of the 1870s, including the fraudulent census data and the segregated institutions that followed emancipation, was a product of a particular ideological environment in which pseudoscientific frameworks were used to justify social and political arrangements that existed for economic and cultural reasons. The federal Indian policy of the early 1900s that produced Canton was a product of a particular moment in the relationship between the federal government and indigenous nations, shaped by land acquisition interests, political patronage, and the assimilationist ideology of the boarding school era. Under this interpretation, each case has its own causes, its own responsible parties, and its own historical explanation. The commitment of Elizabeth Packard was enabled by Illinois law and the specific dynamics of her marriage. The Central Lunatic Asylum for Colored and Sane was the product of Virginia's post-war politics and the broader national framework of racial segregation. Canton was the product of South Dakota congressional politics and federal Indian policy. These are different institutions in different states, operated by different people, during different decades, for different stated purposes. Connecting them, under this reading, requires selecting specific examples from a much larger and more varied historical record and treating the similarities between them as more significant than the differences. A pattern is only a pattern if you choose the right examples. Choose different examples and a different pattern, or no pattern at all, might emerge. That argument is not without intellectual merit. Historians are rightly cautious about narratives that impose too much unity on a complex and varied record. The danger of finding patterns across disparate cases is that the pattern can become a lens that filters out contradicting evidence, leaving only the examples that support the narrative the investigator is already inclined toward. That is a real methodological risk, and it is a risk that anyone examining these cases honestly needs to hold on to, because the alternative, accepting a unified pattern without subjecting it to scrutiny, produces its own distortions. But this is where it becomes unclear, because the argument that these cases are simply separate products of their respective times depends on a specific assumption. It assumes that the separateness of the cases is the most important feature of the evidence, and that assumption begins to weaken when you examine not the differences between the cases, but the similarities in their structure, because the structure, the specific arrangement of who had power, who lacked legal recourse, who was harmed, and who benefited, does not vary between the cases in the way that the institutions, the time periods, and the populations do. The surface details change. The structural arrangement does not. In every case examined in this investigation, the population subjected to institutional commitment shared a specific set of characteristics. They had limited access to legal recourse before the commitment occurred. They could not easily challenge the commitment from inside the institution once it was complete. The legal or administrative mechanisms that might have allowed them to contest their placement either did not exist, were inaccessible to them specifically, or required external intervention that the system did not provide and that they could not independently secure. And in every case, the people who held the authority to initiate the commitment stood to gain something from its occurrence. Not always money directly. The historian Richard Fox, who studied California's commitment records during this period, found that California had the highest rate of insane commitments in the nation during the decades following the Civil War. That finding alone is not necessarily significant. Population growth, urbanization, immigration, and the economic pressures of a rapidly developing state could all contribute to higher institutional commitment rates. But Fox's research also documented patterns within those rates that are more difficult to explain through demographic factors alone. The people most likely to be committed were people who had something that could be administered, sold, or transferred during their confinement. The correlation between commitment and the presence of transferable assets is not the kind of pattern that random institutional error produces. And then there is the statement made by a superintendent of one of California's state asylums during this same period. The statement is documented in the historical record and has been cited by multiple researchers who have examined California's institutional history. The superintendent wrote, in his own words, that the hospitals would continue to be the receptacle for all forms of human wreckage regardless of law and justice. He was not writing in private correspondence that he expected to remain unseen. He was putting his understanding of the institution's function into the record, apparently without particular discomfort about what that understanding revealed. The hospitals were receptacle. The criterion for placement was not clinical. Law and justice, in his framing, were not the governing principles. Whatever was actually governing the institution's intake, in his own assessment, it was something other than those things. That statement is worth sitting with carefully. An institutional superintendent describing his own facility as a receptacle for human wreckage, operating regardless of law and justice, is not making a subtle or ambiguous claim. He is describing a function that is explicitly disconnected from the legal and clinical frameworks that are supposed to govern institutional commitment, and he is describing it without apparent concern that this description would be seen as an indictment. Which raises a question. Was he describing something that was openly understood within the institutional culture of the period, something that the people operating the system acknowledged privately even when the public framing was different? That question cannot be answered with certainty from the available record. What the available record shows is a superintendent who felt comfortable enough with his description to put it in writing, in a context where it would become part of the documented history of the institution. That level of comfort suggests something about the environment in which he was operating. It suggests that the description was not a confession of wrongdoing that he feared would be used against him. It was simply an accurate account of how the institution worked, stated plainly by someone who did not feel the need to conceal it. Some researchers look at the Contra Costa case, the California commitment rates, and the superintendent's statement and see confirmation of the second interpretation. The pattern is there, they argue, not because selected examples have been arranged to produce it, but because the record itself contains it when examined without the prior assumption that the cases are separate. Others remain cautious. They note that a single case in Contra Costa County, a single statistical finding about California commitment rates, and a single statement from a single superintendent are not sufficient to establish a systemic pattern across the entire country and across multiple decades. The caution is methodologically sound. Individual pieces of evidence do not make a pattern by themselves, but the evidence is not individual pieces examined in isolation. It is a sequence of cases spanning different states, different decades, different populations, and different institutional forms that share a structural consistency that becomes more difficult to explain as coincidence the further the sequence extends. That consistency does not prove the second interpretation. It does not establish beyond reasonable doubt that the asylum system was consciously designed to function as a tool for removing inconvenient people and transferring their assets. What it does is make the first interpretation, that these are simply separate products of their respective times with no meaningful connection, increasingly difficult to maintain without accounting for what the structural similarity requires. Neither interpretation has been resolved by the historical record. The disagreement between them is real, and it continues among researchers who have examined this material carefully. What is harder to dispute is what the superintendent wrote, plainly and without apparent concern, in his own words. The hospitals would continue to be the receptacle for all forms of human wreckage regardless of law and justice. He said it. He wrote it down. And the cases that surround that statement before and after it make it more difficult with each edition to read it as an exception rather than a description. Sometimes the clearest way to understand how a system works is to watch someone enter it deliberately, with full awareness of what they are doing, and then observe what happens when they try to leave. That kind of test does not require access to internal documents or administrative records. It requires one person willing to go inside and report honestly on what they find. In 1887, that person was a 23-year-old journalist named Nellie Bly, and what she found during 10 days inside the women's lunatic asylum on Blackwell's Island in New York produced a report that triggered a grand jury investigation and remains one of the most precise first-hand accounts of how the institutional commitment system actually functioned from the inside. Bly was working for Joseph Pulitzer's New York World when she accepted the assignment. The plan was straightforward. She would feign mental illness convincingly enough to be committed to Blackwell's Island, spend time inside observing conditions, and then report on what she found. She checked into a boarding house under the name Nellie Brown and behaved in ways that convinced the people around her, then a judge, then multiple examining physicians, that she was genuinely mentally ill. The commitment was processed. She was transferred to the asylum on Blackwell's Island, and from that point forward, she stopped pretending entirely. She spoke normally. She answered questions directly and coherently. She made no effort to appear confused or disturbed. She behaved, by her own account and by any reasonable observation, exactly as a sane person would behave in an unfamiliar and difficult environment. And the staff did not notice. Not in the sense that they noticed and chose to ignore it. They genuinely did not register the shift. The woman who had been committed as mentally ill was now behaving with complete clarity, and the institution continued to process her as a patient whose illness was simply presenting in a particular way. That detail is the one that sits most uncomfortably within the explanation that the asylum system was primarily a medical institution doing its best under difficult conditions. A medical institution whose staff cannot distinguish between a person feigning illness before admission and the same person behaving normally after admission has a diagnostic problem that goes beyond limited scientific knowledge. The gap is not between what the physicians knew and what modern medicine knows. The gap is between what the physicians observed and what they concluded from their observation. Bly was behaving normally. They concluded she was seriously ill. The observation and the conclusion pointed in opposite directions, and the conclusion won. Bly recorded something specific about this dynamic in her account. She noted that the more sanely she acted, the more convinced the staff became that she was genuinely and seriously mentally ill. That observation describes a closed interpretive loop. Normal behavior inside the institution was read as evidence of illness rather than as evidence of health. A person who argued clearly and coherently that they did not belong there was understood to be exhibiting a symptom, the symptom of a mentally ill person who lacks insight into their own condition. A person who was distressed by their surroundings was exhibiting another symptom. A person who was calm was exhibiting yet another. Within this interpretive framework, there was no behavior available to a patient that could not be classified as evidence supporting the diagnosis that had been assigned at admission. The diagnosis preceded the observation. The observation was then filtered through the diagnosis, and the result was always the same. This is where it becomes unclear in a very specific way. A diagnostic system that cannot be falsified by the behavior of the person being diagnosed is not functioning as a medical system in any meaningful sense. Medical diagnosis, even in its most imprecise historical forms, depends on some relationship between observation and conclusion. The observation should, at some point, be capable of producing a conclusion that contradicts the initial assessment. If no behavior available to the patient can produce that contradiction, then the initial assessment is not functioning as a medical diagnosis. It is functioning as a label. And labels, unlike diagnoses, do not require ongoing validation from observation. They simply persist until someone with authority decides to remove them. During her 10 days inside Blackwell's Island, Bly documented the population she found around her. What she described was not primarily a population of people whose mental illness was severe enough to require institutional care. She found women who had been committed by their husbands. She found immigrants who had arrived in the country without English language ability, had been processed through a legal and medical system conducted entirely in a language they could not understand, and had been placed inside an institution from which they had no path out because they could not navigate the system that would have been required to challenge their placement. She found patients who had been there for extended periods without any clear clinical reason for their continued confinement, and without any clear process underway that might result in their release. That population, described by a person who entered the institution with full awareness and observed it with the journalist's trained attention, matches the structural pattern that has appeared across every other case in this investigation. The people inside were disproportionately people who lacked the legal standing, the language access, the financial resources, or the external support necessary to challenge the system that held them. They were not there because the system had accurately identified their need for care. They were there because they could not effectively resist being placed there, and once inside, they could not effectively work toward leaving. The report that Bly published on October 9, 1887 produced results that the official account of the asylum system points to as evidence of the system's capacity for self-correction. The publication triggered a grand jury investigation. The city of New York increased the asylum's annual budget by a significant amount. Changes were made to conditions at the facility, and the asylum itself was eventually closed. Under the official reading, this sequence demonstrates that when the public was made aware of institutional failures, the democratic and legal mechanisms for correction functioned as they were supposed to. The system was exposed. It responded. It changed. But this is where the timeline does not fully match the conclusion drawn from it. The changes that followed Bly's report were changes to the conditions inside one facility in one city. The grand jury investigation examined Blackwell's Island. It did not examine the broader structure of commitment law. It did not address the legal mechanisms that made admission easy and exit difficult. It did not change the standard of evidence required for commitment in New York or in any other state. The budget increase improved the physical conditions at one institution. It did not alter the process by which people arrived there or the process by which they might leave. The correction, in other words, addressed the surface without touching the structure. And the structure, as Bly's own account made clear, was the more important problem. She was explicit about this in her report. Getting in was easy. Getting out was not. Those two observations, placed together, describe something more fundamental than overcrowding or inadequate funding. They describe a system whose entry and exit mechanisms were not symmetrical. Entry required the word of a person with legal authority over you. Exit required navigating a process that the person inside often had no independent means of accessing. The asymmetry between how easy it was to enter and how difficult it was to leave was not a resource problem or a staffing problem. It was a structural feature, and the grand jury investigation that followed Bly's report did not address it. The sterilization cases add a dimension to this that Bly's account did not directly cover, but that belongs in the same investigation. After the Supreme Court decided Buck v. Bell in 1927, more than 30 states enacted sterilization laws. Over the following decades, more than 60,000 Americans were sterilized without their consent. The majority were people in institutional settings, people who had already been classified by the same system that had committed Elizabeth Packard, that had built Canton, that had held the immigrants Bly found on Blackwell's Island. The institutional classification came first. The sterilization followed, and in many cases, people were admitted to institutions specifically in order to be sterilized and then released. The institution was not serving a long-term custodial function in those cases. It was serving as the legal mechanism through which a medical procedure could be performed on a person without requiring their consent. That detail sounds minor at first, in the sense that sterilization is a different action from indefinite commitment and belongs to a different part of the legal and medical history of this period, until it is examined more closely alongside the question that has run through every case in this investigation. Who benefits from the outcome? In the sterilization cases, The benefit was not financial in the direct sense of property transferred. It was demographic. The explicit argument used to justify the sterilization programs, including the one endorsed by the Supreme Court majority in Buck v. Bell, was that preventing certain populations from reproducing served the broader social good. The populations selected for sterilization were disproportionately poor, disproportionately from communities with limited political power, and disproportionately people who were already inside institutional systems that had classified them in ways they could not effectively contest. The 7-minute jury verdict that freed Elizabeth Packard after 3 years. The logbook entries listing novel reading and domestic trouble as causes of commitment. The fraudulent census data used to argue that freedom caused insanity. The Canton facility built for political patronage and used to hold people whose crime was practicing their own ceremonies. The Contra Costa couple committed while the wife held 74 acres of land. The superintendent who wrote plainly that the hospitals were receptacles operating regardless of law and justice. The immigrants on Blackwell's Island who could not understand the system processing them. The 60,000 sterilizations. These are not the same event. They are not the same institution. They are not the same population or the same decade or the same legal mechanism. But they share something that is difficult to account for under the explanation that each was simply a separate product of its time. In every case, the person subjected to institutional authority had limited means of resisting that authority before it was applied, and limited means of challenging it after. In every case, the people with authority to apply it had something to gain from its application, whether that was property, land, economic benefit, political standing, or the elimination of a presence that had become inconvenient. And in every case, the outcome followed the same basic shape. Someone lost something, and someone else kept it. Some believe that shape is the evidence, that the consistency of who lost and who gained, across different cases and different periods, is itself the most important finding in the record. Others disagree. They hold that each case must be understood within its own context, and that connecting them imposes a unity that the historical record does not actually support. That disagreement has not been resolved. It continues among people who have studied this material carefully and arrived at different conclusions from the same evidence. What is harder to argue with is the observation Bly made after 10 days inside a system she had entered voluntarily and observed with full awareness. Getting in was easy. Getting out was not. She proved in 10 days what Elizabeth Packard had spent years trying to explain. The system was not primarily designed to identify the people who needed care and provide it to them. It was designed to hold whoever was placed inside it. Whether that design was intentional or accumulated is the question that the record raises without answering, and it is a question that the evidence, taken as a whole, does not allow to be set aside as easily as the official explanation would prefer. There is one more case that belongs in this investigation. It does not involve an asylum in the traditional sense. It does not involve a commitment proceeding or a logbook entry or a fraudulent census, but it involves the same question that has run underneath every case examined so far. What happens when the authority to classify someone as unfit is held by people who benefit from that classification? In 1927, the Supreme Court of the United States decided a case called Buck v. Bell. Carrie Buck was 18 years old at the time the case reached the court. She had been classified as feeble-minded and committed to the Virginia State Colony for epileptics and feeble-minded. The classification rested on a claim about her mental capacity that was, by any careful examination of the record, not supported by the evidence available at the time. Carrie Buck was not feeble-minded. She had become pregnant after being raped by the nephew of her foster family. Her foster family, facing the social consequences of that pregnancy becoming visible, had her committed. The commitment served their interests. The classification that followed served the state's interest in a different way. Virginia had passed a sterilization law. The state wanted to test it in court. Carrie Buck was selected as the test case. The legal process that followed was not designed to protect her interests or examine her situation carefully. It was designed to produce a Supreme Court ruling that would allow the sterilization law to stand. Her legal representation was provided by a lawyer who, the record later showed, did not conduct an adversarial defense. The case was built around her, not for her, and the Supreme Court ruled 8-1 in favor of the sterilization law. Justice Oliver Wendell Holmes wrote the majority opinion. The reasoning he offered was framed in the language of social benefit. Society, in his argument, had the right to prevent people classified as manifestly unfit from passing their condition to future generations. The classification came from the same institutional system that had produced every other classification examined in this investigation. The benefit went to the state and to the social order the state was constructed to maintain. Carrie Buck was sterilized without being told what was being done to her. She did not learn the full truth of what had happened until much later in her life. After 1927, more than 30 states enacted sterilization laws modeled on the Virginia statute the Supreme Court had upheld. The people sterilized under those laws were drawn disproportionately from institutional populations, people who had already been classified, people who were already inside systems they had limited power to contest. The total number of Americans sterilized without their consent from the 1920s through the mid-1970s exceeded 60,000. That number spans 5 decades. It spans multiple administrations, multiple political environments, multiple shifts in public understanding of science and medicine, and it persisted across all of them. The Virginia sterilization law that was used in Carrie Buck's case was examined carefully by legal scholars in Germany in 1933. The Nazi government enacted its own sterilization program that same year, explicitly citing American precedents as part of the legal and scientific framework they were drawing on. The American model was not fringe material to the people examining it from outside. It was a functioning legal system that had been upheld by the highest court in the country. At the Nuremberg trials after World War II, some defendants cited Buck versus Bell in their defense. They pointed to the American program as evidence that what they had done was not unprecedented. The Supreme Court ruling they cited has never been formally overruled. It remains in the legal record. That fact sits at the end of this investigation in a particular way. The case that authorized involuntary sterilization of Americans classified as unfit by institutional systems whose classification procedures have been examined throughout this entire account. That case is still on the books. It was not corrected. It was not struck down. It was set aside in practice by later civil rights legislation and shifting legal norms, but the ruling itself was never formally overturned. The legal authority it established was never explicitly removed. And so the question that Nellie Bly raised in 1887, the question that Elizabeth Packard's 7-minute verdict raised in 1863, the question that the Canton Cemetery near the fifth hole of a municipal golf course raises without anyone to ask it, is still waiting for a clean answer. Was this a system that broke down? Or was it a system that functioned as it was built to function, serving the interests it was built to serve, until enough external pressure forced changes that the system itself showed no sign of producing on its own? The honest answer is that the record does not resolve that question with certainty. What it does is make the breakdown explanation increasingly difficult to maintain as the only available account. A system that breaks down produces random errors. This one produced consistent ones. A system that breaks down corrects itself when the errors are identified. This one required sustained external pressure, public exposure, legal challenges, and in some cases federal legislation to produce changes that the internal mechanisms never generated independently. A system that breaks down eventually stops producing the same outcome. This one produced recognizably similar outcomes across different populations, different decades, different legal frameworks, and different institutional forms. None of that proves the stronger claim. It does not establish beyond reasonable doubt that every case in this investigation was part of a single coordinated design. History rarely works that way. Systems do not require central coordination to produce consistent outcomes. They require only that the incentives align consistently, that the people inside them benefit from the outcomes they produce, and that the people harmed by those outcomes lack the power to force change from within. Those conditions do not require conspiracy. They require structure, and the structure, across every case examined here, was remarkably consistent. Someone was removed. Something was taken. Someone else benefited. The paperwork was completed, and the official record described it as medicine, or as law, or as policy, or as administration. The language changed. The outcome did not. That is where this investigation leaves the evidence, not with a conclusion, but with a question that the evidence keeps asking, across more than a century of records, in the handwriting of judges, and the logbooks of institutions, and the published papers of physicians, and the testimony of elders, who remembered what Kenton meant to the children who heard its name. Who benefits when the paperwork writes itself? That question has been asked throughout this account. The record does not answer it cleanly, but it does show, with a consistency that is difficult to explain away, who kept ending up on which side of the wall. And it shows that the wall, in every case, was built with the full authority of law, medicine, and institutional power behind it. The people inside had limited means of contesting any of it. The people outside had limited reasons to try. And the system continued, as the California superintendent wrote in his own words, regardless of law and justice, until something from entirely outside it finally forced it to stop. Some believe that something has stopped it. Others are less certain. The question of where those walls exist today, in different forms, under different names, with different paperwork, is one this investigation does not claim to answer. But it is a question that the record, taken as a whole, does not allow to be set aside simply because the institutions described here no longer exist in the forms they once took. Institutions change form. The questions they raise do not disappear with them.